Welcome everybody, and welcome especially to Professor Saadia Yacoob for joining us on this regular Zoom meetings that we've been holding for the last year or a couple of years actually, but more particularly over the last year, that we've been looking at ethical frameworks that we should more seriously look at in the study of Muslim societies, not only in the past but also in the present. So I really appreciate the work of Saadia Yacoob on Islamic law and gender. I know that apart from what she has said in her introduction to herself, I mean, she's an assistant professor in religious studies at Williams College, but she's also studied Islamic law in Jordan. So and has been looking very carefully at texts and the textual intellectual tradition in Islam in thinking about Islamic law and particularly gender rights. So this presentation of yours, thank you very much for sharing that with us today. Tamkīn, autonomy in Islamic law, I think is a very, very interesting way of putting together, the concerns of freedom, which one might associate more with modern ideas of ethics and morality, together with how these were articulated or debated in classical Islamic law, particularly as I see in your abstract that you're looking specifically at, the Hanafi tradition as such. So I invite you then to do your presentation. You've got about 30 minutes to 40, and for 30 to 40 minutes. After that, we'll open up for a comment and discussion, which will, we'll see how far it goes, but our maximum will be about an hour and a half when we wrap up for everything. Okay. So please go ahead and start. I know that you've got a PowerPoint to share, so please go ahead and go back to that.
All right, well, thank you so much for inviting me. I want to thank Abdul Qadir Tayyib for inviting me to give a talk in your series, and to Ala, I don't know if I'm pronouncing that properly, Ala Hurani, for all of his efforts in putting this together. And thank you to all of you for coming to the talk, and I look forward to hearing from you and being in conversation with you in the Q&A session. So my talk today will take up ongoing scholarly discussions on the consent of the enslaved woman to be taken on as a concubine. This is something that has been a subject of a lot of controversy and conversations back and forth. Now, the issue of women's right to consent and sexual autonomy in Islamic law has been a subject of significant debate. So I was talking about, this organization, Heart, Women and Girls here in the US, and the ways in which they've been trying to raise not only awareness about sexual violence in the Muslim communities, but also provide faith-based sex education to imams, Muslim chaplains, community leaders, and things of that nature. While they provide some training in physical spaces, much of Heart, Women and Girls work happens in virtual spaces. Their website lists a tremendous number of resources that they have developed that are freely available. On their Facebook and Twitter accounts, they regularly hold webinars on different topics and also put out infographics that distill their work into quick and easily digestible sound bites. For example, during Sexual Assault Awareness Month, they posted an infographic on Facebook, "Sexual assault is not zina." The post read, "Sexual assault is the use of physical, emotional, and/or spiritual power and control to dominate another person using sex as a weapon. Victims are oppressed by perpetrators. Zina is a consensual sexual act that does not involve the use of power. They are different." Another example was the simple but powerful words that they shared on this infographic: "Consent is fard." The text of the post reads, "Sexual activity and intimacy without consent violates its sacredness revealed by God. This is also marital rape. Across all types of relationships and interactions, consent is fard." From these infographics, we can see that Heart, Women and Girls works not only to change the discourse of the American Muslim community around sexuality, but also makes fiqhi claims, or claims about, the kind of legal designation of consent and things of that nature, about the obligation of consent in sexual intercourse, actively producing religious knowledge. So part of what I'm trying to argue here is that this is not just a kind of awareness raising, but they're actually sort of engaged in developing a certain kind of religious knowledge around consent in sexual intercourse. These conversations on sexual violence were most recently fueled by ISIS's sexual trafficking of Yazidi women. Here in the US, this was like one of the big things that was constantly being talked about, and a lot of Muslims felt the need to respond to it. Their claims that this was legitimated by Islamic law has sparked multiple conversations as Muslim scholars found themselves having to explain historic Muslim practices of concubinage. Omar Suleiman, a prominent American Muslim preacher and civil rights activist, presents a revisionist account of concubinage by arguing that Islam, and in this context, he's largely talking about revelation and the prophetic practice, allowed for concubinage in relation to captive women in order to relieve them of a greater injustice. Women who were captured in warfare were often compelled into sex work and also sexually abused by their captors. In such a situation, Suleiman argues, Islam prohibited forcing enslaved women into sex work and encouraged the Muslim captors to emancipate and then marry or marry off these women as a form of quote unquote reintegration into society. In all these possibilities, he argues, women had full consent and their choices were respected. The practice of concubinage in particular is presented as an intimacy between enslaver and enslaved, and a form of integrating enslaved women into the household. This quote unquote intimacy, he argues, was predicated on the consent of the enslaved woman. As proof, he offers a legal scenario from Muhammad ibn Idris al-Shafi'i's legal text, Kitab al-Umm, in which a man who kidnaps and engages in sexual intercourse with an enslaved woman is punished for zina, and the enslaved woman is taken from him. As the man sexually violated the enslaved woman, Suleiman argues, he is given the had punishment and the enslaved woman is emancipated. For Suleiman, this scenario is a clear affirmation of the enslaved woman's right to consent. Once an enslaved woman entered the household and the male enslaver began an intimate relationship with her, she was promoted, quote unquote, this is the language of Omar Suleiman, she was promoted to the status of a wife in that no other man could have sexual intercourse with her, she could not be sold, and she was treated as a member of the household. Now, this is a YouTube video where he's giving this lecture, and then he gets criticized for the fact that the text that he's using from Kitab al-Umm is actually referring to somebody who sexually violates an enslaved woman that he has not enslaved, so he's not the enslaver. So in that case, it's a case of rape rather than one of an enslaver taking on an enslaved woman as a concubine. Suleiman is not alone in his insistence that enslaved women could not be taken on as concubines without their consent, and that concubinage was a form of integrating slaves into the household of the enslaver. In her book, Doubt in Islamic Law, Intisar Rab makes a similar claim. In a section on doubt and competing rules of contract law, she asserts that concubinage was permitted in Islamic law under the assumption that such a relationship would create a semblance of a familial relationship between the male enslaver and the enslaved female, similar to the marriage relationship. This sexual relationship, however, could only be established based on mutual consent. So both Omar Suleiman and Intisar Rab are both sort of making this argument that it was a consensual relationship. This, the enslaver could only take her on as a concubine if she consented to it, and that essentially concubinage was allowed because it was similar to marriage and a means by which an enslaved woman could be integrated into the family and kinship network of the enslaver. In her article, Concubinage and Consent, Keisha Ali responds to Rab's assertion, arguing that one would be hard-pressed to find this emphasis in pre-modern Islamic law on the right of the enslaved woman to consent to concubinage. In making her argument, Ali reads against the silence in legal discourse on this ethical question. While there is significant conversation in legal texts that the consent of an enslaved woman was not necessary for the validity of the marriage contract, there's no explicit conversation about the necessity of consent in concubinage. Given the silence, it would be absurd to argue, Ali concludes, that the law granted an enslaver the right to forcibly marry his female slave and engage this issue in great detail, but then her consent if he wanted to have sex with her, they made no explicit statement about that requirement. So this is part of the problem and why there's so much back and forth, because there are no explicit texts or no explicit discussions in the legal text about whether or not her consent was necessary. And for Keisha Ali, that silence itself tells us, that consent was not seen as necessary. Jonathan Brown's new book, Slavery and Islam, is the most recent engagement with the issue of consent and concubinage in Islamic law. While working on the book, Brown gave public talks and wrote for a more public audience on the moral and theological dilemma faced by Muslims who wish to uphold the Quran and prophetic example as authoritative, a moral framework that did not outlaw slavery. In an essay titled The Moral Problem of Slavery, Brown devotes significant attention to the issue of consent and concubinage. Following Keisha Ali's argument, he also insists that enslaved women did not have the right to consent in concubinage. As Hina Azam has demonstrated in her work, Islamic law did not recognize sexual violence within licit sexual relationships. As sexual intercourse in Islamic law was considered licit only in marriage and enslavement, consent of the woman was assumed in both contexts. In the case of marriage, he argues, consent was assumed due to the nature of the marriage contract. In concubinage, however, consent was largely irrelevant, as enslavement granted the male enslaver the right to make sexual use of his female slave. Quote, the relationship itself entailed ongoing consent for sex. In anticipating the reader's doubtless visceral reaction to the law's callousness towards the enslaved woman's sexual autonomy, Brown attempts to demonstrate that in social practice, neither free nor enslaved women could practice meaningful consent, as families often coerce female kin into marriage as well. The protection of both wives and concubines, he argues, was adjudicated by the law, not through consent, but instead through the principle of preventing harm. Wives and concubines could not claim rape, but they could claim sexual harm and abuse as a way of asserting their sexual autonomy. So he wants to make the argument that there are ways of addressing that kind of harm that can come from sexual coercion without needing to legally construct it as rape. In this talk, I engaged this ongoing conversation by turning to juristic discussions on Tamkīn as a means of thinking about sexual autonomy in Islamic law. It is through an interrogation into the law's conception of sexual intercourse and sexual desire that we can begin to see how the law recognized or didn't recognize and adjudicated the sexual autonomy of individuals. To get at these questions, I will focus on a discussion on illicit sexual intercourse or zina and the legal construction of women's culpability in zina in the legal works of an 11th century Hanafi jurist, Muhammad bin Ahmad al-Sarakhsi. This discussion, centered on the concept of tamkin, demonstrates that female sexual autonomy was defined by the ability to acquire ownership over the transaction of one's sexual commodity. As such, a woman's sexual autonomy was dependent on her legal status. Was she free, enslaved? Was she an adult? Was she a child? Was she a virgin or a non-virgin? And the exercise of that autonomy was understood in a transactional framework. This conception of female sexuality complicated the possibility of centering meaningful consent in every instance of sexual intercourse. Now, in Islamic law, sexual intercourse between individuals is restricted to marriage or concubinage. This legal permissibility, however, is constructed along multiple gendered asymmetries. So free adult men are permitted polygamous marriages and also concubinage if they have the financial means to do that. There are different legal opinions regarding the ability of enslaved men to marry or take on concubines. So this becomes a legal issue in that, like, what about enslaved men, right? What do they retain of the rights that would be granted to free men around marriage and concubinage? The Hanafi legal school in particular only permits enslaved men 2 wives concurrently. So they sort of, half it from the 4 to 2, and does not grant them the right to concubinage. Beyond marriage and concubinage, all other sexual relationships are criminalized under the category of zina, and punishment is determined based on the legal status of the individual involved. The punishment for zina is harsh, lashing in the case of fornication and stoning to death for adultery. As the punishments are severe, the standards of evidence are stringent, requiring 4 male adult witnesses to attest to the act of penetration in an area that is not considered private. Furthermore, any level of doubt about the action typically resulted in the penalties being dropped altogether or reduced to discretionary punishments. Now, the Hanafis are distinct from the other Sunni legal schools in their legal definition of sexual intercourse. They distinguish between a legal and common sense understanding of sex, arguing that a legally actionable act of sexual intercourse must be characterized by 2 elements. One is that it must be a vaginal penetrative act. So unlike the other legal schools, the Hanafis did not consider anal sexual intercourse to be a form of zina. It was not seen as equivalent to vaginal intercourse. And secondly, that the penetrative act must be that of a male legal subject who is legally obligated, right, is mukallaf. So to put it more simply, for Hanafi jurists, an illicit act of sexual intercourse was considered punishable only when the man could be held legally and morally accountable for his actions. In such a conception of sexual intercourse, the law's consideration of a woman's participation in the sex act was entirely dependent first on the legal status of the penetrating male. So the woman is defined as the locus of penetration, the mahal. So her consent and her desire only comes into legal consideration once it's determined whether the penetrative act of the man constitutes this act as zina or not. To clarify, let us consider 3 legal scenarios that As-Sarakhsi presents in his discussion on zina. Case A, the rape of a woman by a free adult man. Case B, sexual intercourse between a legally sane adult man and a legally insane woman. And case C, sexual intercourse between a legally insane man and an adult woman. Now, in cases A and B, there's no significant difference between the four Sunni legal schools. In both cases, the man would be convicted of illicit sexual intercourse as he was legally culpable. So if a free adult man sexually violates a woman, he is culpable because he is a free adult man and therefore is mukallaf. And if it's a legally sane man that has sex with a legally insane woman, again, it's a case of zina, and he is legally culpable because he's legally sane and an adult. Similarly, the woman in both cases would be acquitted. In case A, this would be due to coercion, and in case B, due to legal insanity. In the case of an adult sane woman engaging in sexual intercourse with a legally insane man, so that's what we have in case C, here we see a point of significant difference. The 3 other Sunni legal schools would acquit the man due to legal insanity and convict the woman as she is a legally culpable individual and willfully participated in the sex act. The Hanafis, however, would acquit both individuals in this case, holding neither legally culpable for their actions. The reason why the Hanafi jurists, so once they sort of formulate their response in this way, Hanafi jurists now have to explain why a legally culpable woman is not punished for her willful participation in an act of zina. So As-Sarakhsi here provides an extensive explanation and defense of this Hanafi position. His argument is founded on assumptions about the sex body that defines the male sex body through activity and penetration, and femaleness through passivity. This construction of gender is not particular to Hanafi law alone. Indeed, it permeated the Islamic intellectual tradition and the Near Eastern world. Historical studies of gender and sexuality in Roman and Greek civilizations have made similar observations regarding gender that was understood through activity and passivity. Maleness was a subject and femaleness an object. This subject-object dichotomy was not only the mode through which gender was constructed in the ancient world, but it was also fundamental to how those societies understood sexual behaviors and identities. Thus, adult male citizens were understood to be active, whereas women, young boys, enslaved men, and other subjects were understood to be passive and therefore subject to domination. Aristotelian metaphysics also understood sexual difference along the active-passive binary. As feminist historians and feminist philosophers have argued, Aristotle's biological and philosophical concepts of sexual difference saw maleness as active and femaleness as passive. This distinction was partly based on Aristotle's notion of humors, in which males have greater heat in their bodies than females. As the male-generated sperm is seen as the seed from which the embryo grows, the male became the active generative sex. The other sex, the woman, which is woman, contains raw material that is activated by the action of the man. So the generative act is the male act. The male is form, the female is matter. The Islamic intellectual tradition developed in the broader milieu of the Near East, and particularly was influenced by Hellenistic thought. The 11th century, for example, the 11th century Muslim philosopher Ibn Sina had a conception of human reproduction that ascribed to this notion of activity and passivity. He held that both male and females have sperm, and that it is the mixing of the two that leads to conception, though. So that was his theory of reproduction. While reproduction happened with the mixing of the two sperms, Ibn Sina was adamant that it was the male sperm that was the actor, and they often use this term al-fa'il, that acted upon the female sperm. Given the ubiquitous nature of the active-passive binary, it is not surprising that as-Sarakhsi also demonstrates a similar understanding of sexual difference. This active-passive binary then forms the framework for the legal construction of the role of the two individuals in the act of sex. The legal conception of sexual intercourse, as Sarakhsi argues, is dependent on the legal culpability of the active subject in the sex act, which is the man. In this configuration of sexual intercourse, the man acts directly on the woman. So he uses this term, al-mubashir lil-fa'l, who is then, and the woman is then subsidiary, she's a tabi'a, responding to the male act of penetration. In this legal framing, the very definition of sexual intercourse is dependent on the action of the man. While he is the active subject, the woman is rendered the receptacle or the locus, and they use the term al-mahal, where the sex act occurs. So she is the mahal of where penetration happens. Going back to our legal scenario in which a legally culpable woman commits zina with an insane man, the Hanafi position of acquitting the woman is justified by this construction of the sex bodies. Since the male subject is the very source of the act itself, if he is not legally culpable, then his penetrative act carries no legal significance. As the man's legal accountability in this case is hindered by insanity, which gives him immunity from punishment, no legally recognizable sex act has taken place. While the construction of male and female subjects along the active-passive binary is shared by other legal schools as well, the Hanafi legal school is unique in centering the very legal definition of sexual intercourse on the penetrative act of the man alone. This legal position of the Hanafis is dependent on assigning passive sexual agency to the woman. So there is a sexual agency of the woman that they recognize, but they construct it as a passive agency. In construing the woman as a receptacle where the penetrative act occurs, as-Sarakhsi reduces the woman's role to the enablement of the sex act rather than active participation in it. In this legal imagination of the sex body, the male body acts willfully in penetration and is necessarily animated by desire. We see this most clearly in the Hanafi discussion on the sexual coercion of men. In an entertaining discussion on sexual desire and penile erections, as-Sarakhsi rejects the idea that a man's penetrative act could be devoid of sexual desire. So this is something that they're going back and forth on a lot when they're thinking about whether or not men can be coerced into sex. And they primarily, when they're talking about men being coerced into sex, they're not thinking about men being raped by other men, but men being coerced into having sex with women. So as-Sarakhsi rejects the idea that a man's penetrative act would be devoid of sexual desire. As such, Hanafis did not recognize that a man could be coerced into sexual intercourse except by a public authority. And they're very specific about that public authority being a sultan. Coercion in this situation, however, did not entail that the man's erection was not animated by sexual desire. In responding to the argument that the man's erection was an indication of the absence of fear, As-Sarakhsi argues that the erection and penetrative act could be explained instead as a physiological reflex due to his virility. When a man is coerced into sexual intercourse by a public authority, he is understood by the law to be acting out of a restraint that is placed on his volition and a fear for his life and safety. In such a situation, his penetrative act is not intended to fulfill his sexual desire, but instead to protect himself from harm. In this discussion on the sexual coercion of men, we can see the close link drawn by As-Sarakhsi between sexual desire and penetration. In a coercive state, the man's penetrative act, even if in compliance with the coercive demands of another, is an indication of his sexual desire. So it's an indication that his sexual desire is animated, which is why he has an erection, but that is not the intent, right? That his penetrative act is not intended for the fulfillment of his sexual desire, but intended to protect himself from harm. The acquittal is granted on recognition that his penetrative act was not intended to fulfill his sexual desire, but instead to keep himself safe. As the active subject, the male body's act of penetration cannot be coerced. When the male subject penetrates, it is necessarily intentional and desirous. In contrast to the link between sexual agency and penetration for male subjects, the female subject's sexual agency is separated from her physiology. As a receptacle, the vagina is imagined as always available for penetration, regardless of the intent of the woman. The female body as the locus of penetration can be acted upon with or without her volition. As a receptacle, the female body can be penetrated regardless of the intent of the woman. As-Sarakhsi states quite simply, quote, "Her serving as a locus is not negated by coercion." So even if she is coerced, she can still serve her role as being a locus that is penetrated. In the delinking of the receptacle from the sexual agency of the female subject, there's a creation of two separate legal considerations with regards to the female subject. The first legal consideration pertains to the legal status or classification of the mahal itself. That is it a desirous mahal? Is it the kind of receptacle that a man would sexually desire and want to penetrate? And the second legal consideration is the sexual agency of the female subject. To make my point here clear, it would be helpful to consider another scenario of illicit sexual intercourse, which is zina between a legally culpable man and a minor girl. So this would be a young female child who's not yet hit puberty, right? Has not yet hit bulugh. Punishment in this situation is dependent on the legal status of the mahal. If the minor girl is classified as desirable, so the Hanafi jurists distinguish between a minor girl who would be construed as desirable, sexually desirable, and usually that's understood to be a female child who's getting close to puberty but hasn't yet started menstruating, and those that are not desirable. So those would be very young girls, very young children. So if the minor girl is legally classified as desirable, then the man would be punished. As-Sarakhsi makes this most explicit when he argues that in the case of the sexual violation of a minor girl by an adult man, there is no doubt that the act occurred since the man played his role as the penetrating subject and the minor girl as the locus of penetration. The legal minority of the girl, As-Sarakhsi argues, does not diminish the physiological features of the vagina that are desirable. Thus, the woman is able to serve as the locus where sex is performed, even where she did not willingly make herself available for penetration. What is the judgment, however, in a case where an adult man commits zina with a minor girl who is legally considered undesirable? In such a situation, the adult man would not be punished for zina, as the locus of penetration was legally considered undesirable. as punishment for zina is legislated to discourage individuals from satisfying their sexual desire in an illicit manner, and here the man penetrated a locus that is not considered sexually desirable, he is not to be punished as the legal considerations for sexual intercourse are not fully realized. So Sarakhsi kind of writes off his act of penetration as being a kind of sexual perversion of sorts. Like there's something wrong with him that he would desire a female child who is undesirable. For us, Sarakhsi, fulfillment of sexual desire is tied to the locus of penetration and its desirability. As such, penetration of any undesirable locus does not fulfill an individual's sexual desire in a manner that's legally recognized. In a discussion on bestiality and necrophilia, for example, Sarakhsi likens the penetration of an undesirable locus to, quote, inserting the penis into a vessel or peephole. If indeed a man experiences fulfillment through such an act, he argues, it is due to being overtaken by lust. So he distinguishes between lust and desire, or appropriate sexual desire. In these discussions, we can observe that punishment for illicit sex is contingent on the locus's legal construal as desirable. This consideration effectively separates the legal status of the locus from the intent and sexual agency of the female subject. Now, why does this distinction matter in relation to the sexual autonomy of the female subject? This Hanafi separation between the mahal as an object that functioned in legal considerations, separate from the sexual agency of the female subject, creates a dilemma for Hanafi law in defining female legal and moral culpability in illicit sexual intercourse. As the case of zina between an adult man and an insane woman, between an adult woman and an insane man. So this would be where the woman is sane and the man is not, but the Hanafis would not punish the woman. As this case has demonstrated, a woman's intent and participation in sexual intercourse is subsidiary in both the legal definition of intercourse as well as the legal determination of the occurrence of zina. Female sexual agency does not enter into juridical consideration until after the man's act comes into effect. In committing zina with an insane man, the woman does not incur punishment despite her own willingness to desire to engage in sex. Hanafi law has no conceptual framework for recognizing female desire independent of the legal status of the man's penetrative act. If the intent of the woman can be rendered legally insignificant and the female body capable of being penetrated regardless of her consent, what then is the culpability of the woman in an illicit sexual act? Right? Because they're not centering it on the fulfillment of her sexual desire. That's not for them quite the reason why she is legally culpable. We can best explore this conundrum by investigating the legal concept of tamkīn, that I'm translating here more as enablement. But the jurists are using it more as kind of handing over, right, of her sexual commodity. Tamkīn is central to Sarakhsi's understanding of the role of the female subject and the female body in sexual intercourse. The woman's culpability, as Sarakhsi argues, is defined by her willful act to be available for penetration. He states emphatically that the actions of the man and woman in sex are of different categories altogether. As he is the immediate acting party during sex, he is held accountable for his penetrative act. She, on the other hand, is the receptacle of the penetrative act and is thus culpable for enabling the act of penetration by willfully making herself available as a locus. In a case of sexual coercion, if witnesses attest that a man coerced a woman, then the woman does not incur punishment because she was coerced. That is, she refused to make herself available for penetration. For Sarakhsi, coercion does not negate the legal conceptualization of the sex act as having occurred. The legal construction of the vagina as the mahal allows for the Hanafis to adjudicate zina and sexual violation as the same criminal act, right? Because they see sexual violation and illicit sex as both zina. The difference then between a consensual act of zina and sexual coercion is not the intent of the woman to fulfill her sexual desire illicitly, but instead her refusal to enable the illicit penetrative act, or refusal to be a willing locus. Hina Azam makes a similar observation in her work on sexual violation in Islamic law. Drawing on the discourse around sexual intercourse and sexual violence in the first 2 centuries of Islam, she argues that by the end of the formative period of Islamic law, legal discourse coalesced around the categorization of sexual violation as a form of illicit sexual intercourse, collapsing any distinction between coercive and consensual illicit sex. In this conceptualization of sexual coercion, jurists first classified an act as illicit sexual intercourse and only secondarily considered coercion of the woman. Both parties were considered liable for punishment, as both had participated in the act, until it was determined that the woman had been coerced, so her participation was coercive. The woman is first and foremost penetrable and only secondarily a legal and moral subject. Tamkīn then is the conscious, intentional act of the woman as a moral subject to serve as a locus, which is separate from her mahalliya or her locusness, which is a bodily condition. Within this conception of the female body, the woman can be present and enable a sex act without her desire being present. It is intent and willingness to be penetrated that creates culpability for the female subject rather than the fulfillment of her sexual desire. The conception of tamkin in determining the culpability of the woman in illicit sexual intercourse can be better understood if we take into consideration sexual modification of women's sexuality in early Islamic law. Azam describes the tension in early Islamic legal positions on sexual violence as the tension between a theocentric and proprietary ethic. Prior to the emergence of Islam in the Near Eastern world, she argues, the sexual violation of women was understood primarily as a property crime. With the emergence of Rabbinic Judaism and Christianity, sexuality, however, became an increasingly theocentric concern. This was an ethical transformation that was continued and further solidified in the Quran and prophetic example, which both considered licitness in sexual activity to be determined first and foremost as God's command. This reconfiguration of sexuality, Azam argues, brought into legal consideration the internal disposition of an individual, which in turn rendered concepts such as consent and coercion legally meaningful. However, the turn to a theocentric ethic did not fully displace the proprietary ethic. Even the Quran and prophetic example, Azam argues, continue to function with an understanding of female sexuality as a type of commodity. While the Hanafi legal tradition leaned more heavily towards the theocentric ethic and did not provide monetary compensation in sexual violation, as the Maliki legal school did, Hanafi law continued to see women's sexuality through the prism of sexual commodification. Given the tension between a theocentric and proprietary ethic in framing women's sexuality as a commodity, Tamkīn emerges as a mode for thinking about a woman's internal disposition as a legal and moral subject who is both a sexual commodity as well as the owner of her own sexual commodity. And, I'm not going to get into this in this talk, but it's interesting to me that this concept of tamkin also shows up in discussions on sale, right? When it is that you turn over a commodity into the hands of the buyer, the language that is used there often is also this language of tamkin. We see this play out in legal discourse in the sexual agency of the woman being understood through a proprietary ethic. Her legal culpability in an illicit sexual encounter is understood as making available her sexual commodity, that is the locus, for use in an illicit manner. In such a conception of women's sexual desire, the law's focus on women's culpability is not on female desire for sexual intercourse or the fulfillment of that desire in the sex act. The internal disposition of the female legal subject is understood as her volition in making her sexual commodity available for illicit use, rather than her desire for sexual fulfillment through illicit means. The same is not true for men, who are not a sexual commodity, but in fact consumers of female sexuality. And I think this is different from enslaved men. In my book, that hopefully will come out sometime soon, I make the argument that, even enslaved men's sexuality is commodified, but for free men, they're certainly consumers of sexuality. The acting male subject enacts his desire on the female body. His act of penetration becomes a marker of both his intent to fulfill his sexual desire and his participation in an illicit sex act. So how does the focus on the construal of the female body as a receptacle and her sexual agency as enablement or tamkīn help us understand the issue of women's sexual commodity in Islamic law? As my analysis of As-Sarakhsi's discussion on illicit sexual intercourse has demonstrated, his conceptualization of female sexual agency as tamkīn is informed by gendered assumptions about the sex body, which is then framed in a legal language of commodity exchange and transactions. Once the woman as legal subject is rendered passive and desirable, her body read as a receptacle for penetration, and her sexuality commodified, the legal logic around commodity exchange is deployed to understand her sexual agency as her willful act to make available a sexual commodity for illicit use. Women's sexual autonomy in this legal discourse is understood as ownership over their sexual commodity, which then grants them the right to transact it as they wish. In this conception of sexual commodification, marriage is understood as the free woman making available her sexual commodity in a transactional relationship. It is in this transactional exchange that the consent of the free woman holds legal significance. Once transacted, that woman no longer retains the right to consent to every instance of sexual intercourse. So she has the right to consent to entering into a sexual relationship, but not to consent to every instance of sexual intercourse within that marriage. Women's sexual autonomy, however, was mediated through different social factors such as age, enslavement, and sexual status. The legal agency of a minor female child, for example, is hindered by age. Due to her legal minority, she cannot inhabit the full legal agency granted to an adult free woman, and thus does not have full control over her sexual commodity. In the context of marriage, her father or paternal grandfather could compel her into a marriage contract. As a free individual, however, she retains some amount of agency over her sexual commodity. Hanafi jurists thus gave a minor female the right to rescind the marriage upon puberty, provided that it was not contracted by the father and had not yet been consummated. So if a female child was coerced into a marriage before puberty, she had the right to rescind the marriage as long as it was not contracted by the father or the paternal grandfather. An enslaved woman, in contrast, had no ownership rights, and her sexual commodity was bought and sold on the slave market and was the property of her enslaver. Her enslaver could marry her to someone or take her on as a concubine without her consent. It is for this reason that an enslaved woman, once emancipated, was granted ownership over her sexual commodity and was given the right to rescind a marriage that was contracted while she was enslaved. In a prophetic tradition cited pervasively in legal texts on this precise issue, an enslaved woman by the name of Barira, once emancipated, was granted the right to rescind her marriage. Mughith, who was her husband, was desperately in love with his wife, was distressed to learn that she did not wish to continue in the marriage. The prophetic tradition describes the love-stricken Mughith following his wife around town, crying profusely, but she was insistent on her decision. The prophet intervened in this situation, counseling Barira to change her mind. She, however, was adamant, and after confirming that the prophet was advising and not commanding her to remain with her husband, she chose separation. The language used in the prophetic tradition to indicate the freed woman's right to choose at emancipation is couched again in the language of ownership and dominion. According to the hadith, the prophet told Barira, "You have acquired dominion over your vulva, so choose." Right? So it's malakti bud'aki fakhtari. Whereas the free woman has dominion over her own sexual commodity, which she transacts of her own volition in marriage, the enslaved woman acquires that dominion over her body only through emancipation. As a married woman, however, she remains under the dominion of her husband. Thus, the law gives her the option, upon the removal of one form of ownership, to choose to remain or remove herself from the second relationship of dominion, that is marriage. She has this option regardless of whether she was married off by her enslaver or herself chose to marry with the consent of the owner. For As-Sarakhsi, the option at emancipation is granted to the enslaved woman precisely because of this dominion over the woman that is entailed by marriage, the dominion over the wife. Once she is freed, she cannot remain in the second form of dominion that was placed upon her during enslavement. Having acquired freedom from one form of dominion, she retains the right to decide whether she wishes to exit or remain in the second relationship of dominion. Sexual autonomy, then, is another vector where social distinctions are made not along the gender binary, but instead at the intersection of a number of different social categories, enslavement, age, sexual status, things of that nature. We cannot speak of the sexual autonomy of the free wife and the enslaved concubine as a shared designation. Such an approach would fail to recognize the power differentials between them. We can see this hierarchy between the free and enslaved woman maintained through their relation, even through social practices of physical violence. In writing about the enslaved courtesan in early Abbasid Baghdad, Pernilla Marna has noted the role of physical violence in maintaining the distinctions between free and enslaved women. The whip, she argues, was perhaps a distinguishing feature between the free wife and enslaved people. While the practice of whipping an enslaved person might have been common practice, this was not acceptable with regards to a free wife. She narrates, for example, that when Inan, this is one of the Jawari that she looks at in her article, a well-known and celebrated enslaved courtesan was flogged by her enslaver, she cried out that she was a free woman and thus should not be treated in this way. So of course, so there are all these legal discussions about the right of the husband to physically punish to punish his wife through physical violence. But what form of physical violence that could take was clearly a distinction between the free wife and enslaved women. While physical violence was endured by both the free wife and the enslaved woman, the form of physical violence distinguished between their positions in the social hierarchy. They both occupied status as dependents of the husband and the enslaver, but their dependency did not impart a shared position in the social hierarchy. So to conclude, the focus on As-Sarakhsi's discussion on Tamkīn allows us to make a few observations regarding sexual autonomy in Islamic law. A, that sexual autonomy existed on a spectrum. As Lina Salame has observed, no individual in Islamic law has full sexual autonomy. If here we're understanding autonomy as the individual's right to be able to enter into sexual relationships. Even the husband, Salame argues, was obligated to fulfill his wife and his concubine's sexual needs. The sexual autonomy of individuals, however, was asymmetrical, determined at the intersection of a number of different social categories, such as gender, enslavement, and age. From this perspective, the enslaved woman had no legally recognizable consent to her sexual use by an enslaver, given that this construction of her sexual autonomy distinguished her in the social order from the free woman who consented to entering into a sexual relationship through marriage, right? Even if she did not retain the right to consent to every instance of sex, she had the right to consent to enter into that sexual relationship. For the Hanafis, at least, the enslaved man could be coerced into a marriage, entailing that his sexual autonomy was also diminished in relation to free men. The second observation we can make is that sexual autonomy is relational. That is, an individual's sexual autonomy shifts depending on the relation within which the sexual intercourse took place. The sexual autonomy of the free wife is different from that of a free woman. while the wife cannot refuse her husband sex without consequences, as a free woman, she had the right to refuse sex to any man outside that relation. Similarly, the enslaved woman has no right to refuse the sexual use made of her by her enslaver. And she also has no right to consent to marriage, which meant that her enslaver could enter her into a sexual relationship with another man through marriage, regardless of her will. However, as a Muslim woman who was morally obligated to maintain chastity, the enslaved woman had every right to refuse sexual intercourse with any man other than her enslaver or her husband. Even as a wife, so if her enslaver decided to marry her to somebody, she could refuse sexual intercourse with the enslaver, with her enslaver, since marrying her off entailed the loss of his sexual right. This complex mapping of sexual intercourse, however, is not possible if we enter the legal world relying on gender as our primary category of analysis. The idealized conception of maleness and femaleness that I described in As-Sarakhsi's reading of sex, bodies, and intercourse is disrupted and displaced when it comes to intersect with other social identities. As Fatma Sidat has argued, a woman's legal agency and ability to act is determined through the social facts that jurists attach to the female body. Sexual autonomy in Islamic law cannot be understood if we approach it through the conceptions of the autonomous self. We must instead think of the individual in Islamic law as relational, one where the sexual rights and obligations of individuals were determined through their relations to other individuals, rather than as an essential aspect of their own individual self. Thank you.
Yeah, thank you. Saadia, thank you very, very much. Let me just get myself back on my video. So thank you very much for that really great presentation, and also taking us very carefully through the both from the present representation of Islamic law, then taking us back on a very fascinating journey through Sarakhsi and also Islamic legal ideas about sexuality and about the different ways in which we think about individuals and subjectivities. So thank you very, very much for that. We hope that we can read your book or your articles, soon, and please share that with us, and then we can take that up as such. But I'm sure that there are a lot of questions and comments, and I'll open the floor to you. So what we do now is that if you could just indicate to me, since we are a large group, you could just indicate to me whether you want to join. You may, just unmute yourself, and you could also just make yourself visible as well, and then ask your question. Please try to keep your comments and your questions to as briefly as possible. Okay. So if I could perhaps start with my question and comment. I mean, I think that it's fascinating that you were suggesting that perhaps autonomy, I'm fascinated by the opening remarks that you made about these comments made by American Muslim, public, if I can think about them as public representations of Islamic law. But you are sort of in response to that, you are sort of inserting a much more complex and a much more relational understanding of sexuality that you are drawing from Islamic law. Do you suggest that to be sort of a better way to think about, sexuality as well, rather than just focusing entirely on autonomy and on consent as such?
Yeah, thank you so much for that question. I really appreciate that. That's something that I've been thinking about a lot, working on this piece, which is that I think, that part of the problem that I see with these contemporary sort of engagements with the question of sexual autonomy of women in Islamic law, both the concubine as well as the wife, is that it assumes a certain ethic, a certain sexual ethic that is based on a notion of the autonomous self, right? The idea that like you are this sort of bounded individual who, you know, enters into relations of your own volition and should be able to sort of, you know, exit them as you want, and should be able to set up, you know, the kinds of relationships that you want, right? Because you are not understood as a person defined through your relations. You're understood as a person, and who you are as a human, as an individual. And in, you know, in this, I think I've been very much influenced by feminist legal theorists like Nagari Nafin, also Jennifer Nadelsky, who are really trying to, you know, sort of push us to think about autonomy as a more, you know, through a more relational lens. The idea that, you know, the way in which we even develop a sense of self and who we are and who we want to be, and the process of becoming, all happens through our relations, right? Not just to other human beings, but also, you know, to other kinds of subjects and things of that nature. So if once we recognize that, and I think for me, you know, as a Muslim, you know, studying the Islamic intellectual tradition, I want to think about ways in which I can engage with Islamic law, not just through critique, but also as a kind of something that is in conversation with where I am in the contemporary. And that's where I find really useful this way that I've been sort of trying to read Sarsi, that, you know, we can recognize that there are asymmetries, right, in the ways in which they understand sexual autonomy, and that some people clearly have a lot more of it than others do, but that that sexual autonomy is not understood as something that you just have a right to. It's something that is always in relation to other people, and you have obligations sexually to people, right? So, you know, and then what would our conversations look like, and what would our ethical considerations be once we can, you know, step away from a notion of, well, it's my body and it's my sexuality, and therefore I, outside of my relation, decide what I want to do with it. I think, you know, changing our conversation to think more relationally would be far more productive and lead us, I think, to more equitable, you know, sexual cultures than perhaps where we're at now.
So thank you very much for that. I had a follow-up question, but I'm going to allow Aslam, because I see his hand up now. Aslam, please go ahead.
Thank you very much. Assalamu alaikum, everyone. Thank you, Prof, for a beautiful, very insightful talk. As you were speaking, you know, I just couldn't help wondering what would happen if we had a Hanafi judge that had to adjudicate the case of Roger Ailes. He was the CEO of Fox News. And, you know, there was this famous case of him sexually exploiting many of the famous female anchors at Fox News. And obviously he lost his job as a result of this case. But I mean, you've raised issues of autonomy and consent. And I'm just thinking about it within this contemporary American context, where you have these very powerful female anchors coerced into a sexual relationship with an even more powerful CEO. So there is a certain level of consent there. There seems to be an exercising of autonomy, but at the same time, there is also coercion. And I mean, obviously, this presents a huge legal problem. So the question I'm really asking is, you know, how sufficient is a legal discourse for dealing with such complicated issues as sexuality, intent, and so forth? Perhaps just your comments on this case specifically and how it would be adjudicated by a Hanafi judge.
Yeah, thank you so much for that question. That's a really great question, because I think it, you know, it gets at the limits of consent and sexual autonomy as the kind of ethical frameworks through which we think about, you know, the inequities, right, in our sexual cultures. And I think, so Joseph Fischel, who's a professor at Yale, has written on some of this directly. and sort of makes the argument that, the law is one thing, right? That like centering consent of women in law and thinking about what meaningful consent means, right? That like if somebody is consenting to a sexual relationship with somebody who has the kind of power over them that they could destroy their career, do we really consider that to be consent or not, right? Like as a legal conversation, that's one thing. But the problem with a sort of consent and autonomy discourse is, or a sort of individual autonomy discourse, is that, then you can start to, make these arguments, right? That like, well, in some ways her consent is there, right? Because unless it's a sort of physically coercive act, as long as you are consenting to enter into that relationship, even if there's that kind of power differential there is at some level consent involved, and it is an exercise of your own agency, right, in being able to better your situation and things of that nature. But arguing about that doesn't get us at the real problem, which is a sexual culture in which exploitation of individuals, right, and particularly more vulnerable individuals, is rampant. And you can't really address that through conversations about consent and autonomy in a way that I think is most productive. And that's where I think the fact that some of these legal discussions, and again, it depends very much on context. So in a place like the US, for example, Islamic law is not something that's adjudicated in the courts. So, it's not a legal system in quite that same way. It's very much a kind of ethical framework that, communities engage in, right? This sort of conversation about what kind of sexual rights a husband has is something that happens in webinars on marriage and, the khutbah at Friday and things of that nature, rather than something that's being adjudicated in the court. So there, I feel like, this kind of relational nature, of how sex and sexual obligations are understood is a much more productive space than just trying to think about consent of individuals and what kind of autonomy they can exercise, right? So talking about the fact that husbands and wives have a obligation to one another, right, to fulfill each other's sexual desire, right, is an important aspect of sexual ethics, I think, that we do need to think about. Framing it as a right of the husband to, to have sex with his wife, and that the wife should not say no to him, right, is an asymmetry that we should be critical of. But then to start to frame it as through this language of autonomy where, the wife, it's her body and she has the right to do with it whatever she wants, right, is also problematic because it fails to recognize that relationship within which that sex is happening and the obligations created through that relationship for both individuals, right? So I think, there are ways in which the autonomy and consent discourse, might do certain things legally that we do still want it to do, but as a broader politics, I don't think it really helps us as much as we think that it does.
You are muted, bro.
Oh, sorry. So thank you very much, Saadia. Allah, please go ahead.
Thank you very much. My question actually more into details in your presentation about the notion that she had to be desirable. And that what constitute the zina or the crime. So my question, what constitute those are not desirable? Are age and the beauty? And what are the case, in case a woman undesirable, where does she stand in this law and in this debate? Thank you very much.
Yeah, thank you for that question. So they have, very particular ideas of what is desirable and what is not desirable that is much more legally defined than necessarily what that individual desired in that particular sex act, right? So and depending on which time period you're talking about, it can look different. So, you know, so let me begin with what Sarafsi describes as the desirability of the locus is very sort of physiological. He says that, you know, the vagina is supple and it has warmth. And both of those things are conducive to allowing a man to fulfill his sexual desire, right? So now the question is whether, and for him, those physiological features of the vagina, which is why it's desirable for penetration, exists in all female bodies, right? But that doesn't mean that all of them are desirable. So for him, a female child who is of the age that you would not consider to be desirable, right? And so for somebody like Sarafsi sitting in the 11th century, he's clearly talking about social norms, right? That there are clearly ways in which socially at some age, as a girl reaches close to puberty, she comes to be seen as desirable, but, you know, has not yet hit menstruation. But younger girls, right, are not seen as desirable. They're still seen as children. So even though physiologically, right, she as a locus might be conducive to ejaculation, to male ejaculation, she is not construed desirable. Later Hanafis start to make age distinctions. So by the time you get to Ibn Humam, for example, start to talk about like 9, right? And they give examples of Aisha and the fact that like she was 9 when the marriage was consummated, and therefore 9 is definitely a desirable age. So that's one way in which desirability is talked about. There are other conversations about whether or not older women are desirable, right? In the sense that like those who are past the age of reproduction. And, you know, there isn't, Marion Katz's book, I think it's Women in the Mosque, you know, takes this on in more detail. The ways in which the Malikis, for example, make a distinction in the mobility of the older woman versus the younger woman. But then, you know, talks about how by the time you get to the 11th century, there's much more of a collapsing of these differentiations to where even older women who are, you know, postmenopausal are still seen as desirable, even though they are no longer of reproductive age. So, you know, desirability is not entirely about social constructions of beauty either, in the sense that you might recognize that certain women are more beautiful than others, that certainly they talk about certain ethnic groups being more beautiful than others, even recognize that, you know, different stages of the life cycle, certain women are more beautiful than others, but that doesn't mean that they're not desirable, right? There might be levels of their desirability. They are still desirable. So mostly where I've seen the discussions about, you know, something being, or a woman being construed as not desirable, largely has to do with whether they think that she is of the age where men can now start having sex with her.
So if I could just have a follow-up question on that, does that actually then imply that that women who are, or at least who are, or women or girls, for example, who are not considered desirable, will that have an effect on whether the crime is committed or not? Is that sort of connected as such?
Yeah. So, you know, so if a free adult man, for example, you know, sexually coerces a female child who is considered to be not desirable, obviously she would not be punished, both because she is a child, right? And, you know, well, because she's a child, she is not legally obligated. But he would also not be punished because for zina, I mean, he can be punished, you know, for other things, but for zina, he would not be punished because she is not a legally desirable locus, right? And that is then, you know, the analogy that is drawn is to things like bestiality or necrophilia, where, and talking in this kind of language of like, well, sometimes men are overtaken by their lust and they, do things that are, out of the boundaries of what we see as socially appropriate desire. So in that case, you would not punish them for zina. You could punish them for, other kinds of like sexually inappropriate crimes and things of that nature, but certainly not for zina. It would not reach that definition of zina.
Thank you. Ismail Hashim, please. Ismail, please go ahead. Can you hear me? Seems like we cannot hear him. So while we're waiting for that, I don't know if there are the other questions, but I'll ask for Ismail to come in because he is from, he's one of our participants from Morocco, and sometimes we cannot hear him, but he can hear us. Maybe if you cannot hear you, you can also just pose your question on the chat, and then I will read it out for others as well. So, okay, perhaps I wanted to just put another question, if I may, while I'm waiting for this. I don't see any other hands. Just to remind you, if you do have a question.
Fatima, see that hand is up, just to bring to
Oh, okay. It's sort of taking long to get to me. Okay, Fatima, please go ahead.
And hi, Saadia.
Hi.
I want to say welcome to UCT and welcome to our space. My apologies for coming in late. Yeah, when we're in the middle of elections, all sorts of things are happening around us, but it's really great to have you here. And so you might have dealt with this a little at the beginning, but from what Abdul Qadir has just said, I picked up that perhaps you might have, but if you haven't, I'm really interested in how we think about these ideas of autonomy and agency with the process in the process of marriage. And the way in which you're talking about tamkin is making me, I want to push you to ask about how one gives permission to enter into marriage. So consent is required there, but one cannot give, there is no similar process to take back that permission, that consent, right? So that for me is a very interesting understanding or way of looking at what it means to be a person who gives consent, because consent is said to be required, but one cannot take it back. And I think it's interesting for a few reasons around what you're talking about in terms of how gender isn't the only axis of oppression that we look at when we're trying to understand these dynamics, because I think there's also, and this happens as we come from first into kind of third wave feminism, where we're trying to talk about difference, but we end up potentially also losing the power and the analytic aspect of gender. And the way to reclaim it is to reclaim the intersectionality of it, right? And I think you've done just that. That's what relationality and situationality means, right? Situation means it's a multiplicity of issues that come together. It's not just gender. But there's that easy possibility of slipping, where it becomes, oh, this isn't really a gender issue. And so I want to, so maybe it's two questions. It's about the issue of gender and where we place it in all of this analysis. And then it's the issue of how to understand autonomy and consent, not necessarily in the way it gets popularized today, but the way it was historically, even though we're living in concepts of marriage, which are actually neither the past nor the present ideally presented. Sorry if it's a bit of a complicated question, but I think you get where I'm going to.
Yeah, no, thank you for both of those questions. Those are very, get at kind of the crux of part of what I'm trying to do here. So I'll take maybe the first question around, consent and how consent is formulated, because I think that's a really important point that you're raising, which is that, that the idea of consent is the consent, that you agreeing to as a female subject to hand over your sexual commodity to be used by this other individual. But part of what that does is, it seems to me that the necessity for her consent comes from seeing her as a legal and a moral subject, but there's simultaneously this construal of her as a commodity. So, it's as though the female body is two things at the same time, a moral and legal subject, but also a commodity. And so then once she enters into that relationship as a commodity, her right to exit out of it then takes on a different logic, where, now that commodity is in the hands of the husband, right? And you as a commodity cannot say that you want out, right? Just as a buyer, right? It now has control over, the commodity. The commodity cannot decide that it no longer wants to be in the ownership of, of the buyer. It's the buyer who makes that decision to either release it and sell it to somebody else, right? Or somebody else might indicate an interest in buying it, which I think is kind of what the logic of khula is, right? That you say, okay, I'll buy my commodity back, right? So I think there's this kind of, dual way in which the sexual commodification of the female body constructs the woman as two different kinds of subjects, and you see that playing out in the legal logic around marriage. The other thing, around this question that you're asking about, okay, so what do we, how do we sort of step away from this kind of, what I would see as a very white feminist framework that wants to see gender as the sole kind of, factor and, an organizing principle, and then somehow all women being in this shared category of oppressed, to kind of complicate that narrative by noting the intersections of gender with other kind of identities, and yet not losing sight of gender, right, as being something that is at play here. That's something that, I feel, I'm not sure that I fully have a position on that yet, because I see the problem that you're pointing out, and I share that problem. This is something, in the last chapter of my book, I actually kind of very much named that, right? That like that I'm not trying to say, as a lot of other people do, that gender is not an important category through which we can approach the textual tradition, right? Because there's an endless number of people who think that the work that we do is pointless and that, like, gender is not relevant, right? So, I'm not trying to argue that. But on the other hand, I think there's a lot that is lost in both, the complexity of the legal world, but also, and I think more importantly, the power differentials that we miss, right, in naming the oppression that we have an issue with, when we think that, gender is either the only thing, or we can recognize that there are other things involved, but gender is still the most important thing, right? And so then I feel very conflicted, because I think, there have been a number of recent studies that have moved from this kind of argument that, women are oppressed and men are the oppressors in the Islamic intellectual tradition, to saying, well, it's not men, women, it's, elite men vis-a-vis pretty much everybody else. And I think, that's a helpful way to think about it. And I think, in some ways more accurate. But I worry about this construction of a subject, right, that is the elite man or the free man, as the static subject that has power, right, over everybody else. Because I think when you come into the legal texts, that's simply not true. Because, an elite man who is, say, an Arab, right, would have different kinds of legal statuses than an elite man who's not an Arab, right? So I think for me, what's important is to keep an eye on the relation, right, in which power is functioning, rather than the categories, right, that determine whether this person is an oppressor or the oppressed. Those categories are important in understanding the relation and what's happening there. But I think we have a tendency to rely more on the categories as indicating whether or not oppression is happening, which I think makes us lose focus on the material realities, right, of what's happening. And then sometimes when those material realities contradict our identity formations of who's oppressor, who's oppressed, then we feel really uncomfortable naming it.
May I just follow up just with a comment?
Yeah.
So yeah, no, I think you've captured it nicely at the end, Saadia, by talking about the ways in which we end up speaking to what I think are specific identities rather than speaking to specific oppressions.
Right.
Because intersectionality becomes, it gets, for lack of a better word, it gets reduced to identity politics, right? The politics of who you are, as opposed to the politics of what you're experiencing by virtue of your location, i.e. situation, i.e. relationship, right? So I think the way in which you're framing it around relationship it's valuable, because it's valuable so long as we also bring into relationship, or we highlight within relationship, that relationship is about the dynamic, and that dynamic is a power dynamic, right? The dynamic of who is placed where with regard to who, it's in relation to somebody else or something else. And I mean, this is a thing that I teach third year African feminism, and just there trying to teach students that intersectionality is not about my identity.
Right.
That you're actually teaching about oppressions, and it's not an Olympics of oppressions, right? That it is about how oppression happens and the ways in which it is experienced in people's daily lives. So I think that's one way to move toward this. But I mean, I share your dilemma too, in not wanting one axis to be prioritized over others, because I mean, we could easily argue, for example, in the kinds of analysis that we've been doing, class is so empty. I mean, our class analysis, our class space, in the space where we do class work is so empty, except for issues of enslavement. We don't have any other kind of class analysis, and that would be a different kind of oppression. And it would take many women out of the oppressed classes into different classes, right?
Right. No, exactly.
Thanks. Yeah, I'll stop there. We'll go on.
Okay. So there is the question that Ismail wanted to ask. He's typed it into the chat. I don't know if you want to read quickly through that. So it's straightforward, but he's. Can you see that, Saadia, or should I just? Yeah.
Yeah. No, I can see it. Yeah, so if I understand the question correctly, I think the questioner seems to be raising the point that, that there is this way in which even in polygamous marriages, you can't really talk about it entirely as a husband's right to, to have sex with multiple women, because there are legal obligations that he, legal and moral obligations that he enters into vis-a-vis the different wives. And of course, then it's, I think pointing out importantly, the relation between those different wives, and that, there has to be a rotation of, the different wives and things of that nature. So, in that sense, there's a way in which, she also cannot make demands of the, at a time when he is with another wife. But not clear to me, I don't know, Abdul Qadir, if you have a better sense of like what the question is there.
Well, I think he starts from asking whether sexual autonomy in the context of a polygamous family. I think he wants to sort of he wants to suggest that autonomy itself is not a sufficient marker of sexual preparedness, of sexual. Yeah, I think that's what he's saying. I mean, because I'm looking at what he started, the question of sexual autonomy in the context of a polygamous family, especially in the light of what the presenter stressed, that sexual activity must be seen as a duty partners have towards each other, rather than a right of the husband only in polygamous settings. So I think he's trying to stress the idea that even in polygamous marriages, it's not autonomy that determines, sexuality, but rather a set of rules.
Yeah, no, I think that's an interesting point. And I think I find very helpful this distinction that Jennifer Nadelsky makes between individual autonomy, which is very much the kind of, the individual as the subject, right, in liberal legal traditions, versus what she describes as relational autonomy, right? That like we think that we should think about autonomy not as, the right and the ability of an individual, right, where we see the self as an individual and their rights and their ability to make decisions regarding what it is that they want to do, but to recognize that, our notion of self is always tied to our relations to other people, right? And so in that sense, then, the exercise of your autonomy is tied not just to what it is that, you want or, you expect, but in terms of your relations to other people. So I think, I don't want to let go of the idea of autonomy altogether, right? In the sense that I do think that it's helpful for us to think about, there being some kind of boundary, right, between the self and the other, but to recognize how porous those boundaries are, right? And that it's hard to be able to distinguish what that self is in relation to the other. So in that sense, I think that, that idea of autonomy can accommodate a notion of sex as a duty and an obligation, right? While recognizing that you fulfill that, right? Or that you engage in that kind of sexual relationship, because for you, those relations are integral part of, your fulfillment as an individual, right? And so that's where the autonomy is being exercised, rather than making claims about your right to your body and your right to not engage in sex except when you want, right? So I think, this idea of relational autonomy is a helpful way to kind of think about this point that like sex is about duty and obligation rather than just about a right. The other thing I'll say is, and I've been thinking about this in relation to some of the other stuff that I'm reading from Saraqsi, who I spend a lot of time with, is this point that I think there's also something for us to think about in the contemporary period of the ways in which our changing kinship and family structures, as well as our changing ideas about sexual desire, create for different realities than perhaps what were being created in a different context, where you might have this kind of talk about the right of the husband to sex, but it didn't necessarily play out those ways. So, one example would be, which I think is still a continued example in a lot of places in the world, is where people live in extended family networks, right? In that kind of a context, a couple having sex is not just about when the husband wants to have sex, right? Because it might be that he wants to have sex, but right now the whole family is hanging out together, right? And you can't. So there's a restriction on the husband's ability to just make claims about sex because of his relations to other people and obligations that he has to the extended family. right? Because of which, that's a claim that he can't make. Another thing that Saraqsi talks about, in other places in his text is this idea of tazkiyah, where he says this thing that there are two base human desires, the desire for food and desire for sex. And so, you shouldn't just have sex because you want to, right? Even if you can have that sex licitly, you should try to control your sexual desire, because that is how you purify, right, yourself spiritually. So, you should have sex when, it gets to the point that like you really need to fulfill that desire, but otherwise you should try to curb it. So, once you have that kind of ethic introduced into the picture, then you're simultaneously telling the husband that he has a right to sex, but at the same time are also telling him that he shouldn't have sex every time he desires it, right? Because that would be an indulgence of his desire, even if it's a licit indulgence, right? That is not good for him spiritually. That then leads to very different kinds of implications, right, of this claim about the right of the husband than perhaps what we might see now. So I think those are other things that we need to kind of keep our eye on, is that laws can have different implications depending on their interaction with other discourses.
Yeah, thank you very much. I was actually thinking about that when you were talking. Sorry, I'm just come in the light so you can see me more clearly. I think I just realized that if I have the light in front of me, then you can, because it's getting dark. Yeah. So yeah, thank you very much for that. I mean, I was just thinking about that when you were talking about what you call the transactional and the theocratic, to what you pointed out just now. I mean, is this whole idea of of tazkiyah, of ethical refinement, do you think that is part of what you presented as a theocratic? You mentioned this distinction between what was generally called theocratic and transactional foundations, of sexual relations.
Yeah, I find really helpful this distinction that that Hina Azam makes in this tracing that she does for us of the kind of proprietary ethic that exists in the broader Near East, where sexual relationships are largely understood through property relations. And so the sexual violation, what you constitute as sexual violation or adultery did not depend on the intent of the individual, right, but depended on the relation and the property value, right? So you usurped somebody's property by having sex with their daughter, right, and things of that nature, and then the ways in which that shifts fundamentally and brings attention to the individual as a moral subject once you introduce God into the picture, where you maintain chastity not because you are a property of somebody else, but because God does, you want to please God. And so in that sense, I think that, produces a very different kind of ethical discourse and can both place obligations on us that we might not otherwise recognize in a more secular framework, such as, the obligation of the husband and wife to fulfill each other's sexual desire so that, you're not causing them to, pursue illicit means of fulfilling their desire, but also might open up other possibilities, right? In that you can talk not just about the obligation to fulfill each other's sexual desire, but you can also talk about the obligation to control your own sexual desire, right? And that being part of the sexual ethic that we that we think with in in terms of how we conceptualize of what is equitable, safe, and good sex, right? That it's not just about fulfillment of your desire, right? Like our focus is not on a hedonic culture. That's not the goal, right? I think for me, like reading Joseph Fischel's book was very helpful in thinking about this, because for him, coming from a secular framework, it's primarily there is a valorization of a hedonic culture, right? The right to fulfill your sexual desire. And so a need to create a social structure and a sexual culture that allows for individuals to be able to do that. Whereas, within a more religious framework, that is not the purpose, right? The purpose is different. So then what becomes available to you as possibilities of a sexual culture might be different, and something that I think is important for us to think about.
Okay. If I could be permitted, I'm going to ask you one more, although I realize the time. I don't know how are you with your time, but
No, I'm all right. I'm okay. Yeah.
Okay,
Yeah, no, I
so-
really appreciate the opportunity to talk about this.
Okay, so I wanted to ask you something about, maybe raise a question about, the way that you frame the, Sarakhsi's understanding of, of sexuality between, the as an active and between subject and object, or as a passive or an active participant as such. I mean, how would you see that translated in the modern world, which is, especially if you think about, the traditions of Foucault and Saussure as not have, as a cultural world, not necessarily connected to kind of a natural order. I mean, their world seems to be very much, predicated on a particular understanding of a natural order, and then the ethics is based on that. I mean, to what extent do you see, do you see that, continuing in Muslim societies, or do you think that perhaps, one should actually be thinking about a different kind of a natural order, or do you think of this as a cultural world entirely perhaps, constructed by religious values or ethical values that have nothing to do with a, with a kind of with thinking about sexuality, or thinking about sexuality as performing a particular, or as related to a, well, at least for want of a better term, natural order. Yeah.
Yeah, no, that's a really great question. I think, part of it is that, there, and I think, feminist philosophers have certainly made this argument that, we've moved from a kind of conception of the world order and our social order that is based off of, this notion of the natural order of things, to really centering it on biology. Right, so there's a way in which, like, there isn't a kind of metaphysical reality that sort of, determines our social order. But, so Sarakhsi, for example, makes these arguments about, well, this is naturally there needs to be this kind of active-passive relation, right? Because that's the only way that things happen, right? And that for him is a metaphysical reality. But and that is true not just in terms of men, women, but also enslaver, enslaved, parent, child, right? I mean, all of these different kinds of relations. But I can totally see somebody else in a contemporary context making exactly those same arguments and justifying it through biology, right? That, and we see that, and that, like, there's all this kind of talk about how, men have much stronger sexual, drives than women do biologically, and, and therefore we need to have polygamy, and, all of this kind of stuff. So I think, in some ways, we have found other means by which we kind of create some sort of stability to our constructions, right? As not just what we have chosen to make them, but as something natural, right? However it is that you understand what natural is. The question of, like, whether or not that should continue. I mean, I think I'm still very compelled by the argument that Kisha Ali makes in, that article of hers from back in 2007, which is essentially saying that so many of the sort of founding logics of the Islamic law are things that, we can no longer replicate, either because they cannot be replicated in the world anymore, right? I mean, I think at some level it's sort of nonsensical to talk about the man as breadwinner and the wife as home, caretaker of the home, when we increasingly live in economies where that is simply not possible, right? So sometimes it's just something that cannot be replicated, but sometimes it's where we see real moral issues, with that kind of understanding of the social order. But I feel like for me, what I want to think about is, how do we use this intellectual tradition, and in my case specifically law, not just as an intellectual exercise in figuring of deconstruction, right? Of going in and saying, okay, these are their assumptions, and that's not acceptable to us and shouldn't be, and therefore I've deconstructed its authority, now let's build something new. But to actually have it as a kind of intellectual and ethical framework that I'm in conversation with, even though I might be critical of aspects of it. And that's where I think, we can sort of think about, okay, well, we don't want to replicate an idea of active passive, right? But active passive is a certain kind of relation, right? It's a relation with a particular power dynamic, which we might, not be okay with. But centering notions of the self and who you are within your relation to others, right, is something that I think is very powerful ethically. So I think that's kind of where I'm going with this, is that, how do we sort of step away from needing to, say, okay, this is what they think, and now we have to ask ourselves, do we hold on to it or do we let it go? But say, okay, this is what they think. What does it get me thinking, right, about the world that I live in now? And that frees me of having to make those kinds of determinations.
Thank you very much. I think that's a beautiful place to end. I don't see any other questions, but I'm sure that you've raised a lot of questions, and you've raised a lot of people thinking about these issues, certainly. I mean, I liked particularly, not to say that we turn away from autonomy, but what lies underneath, or at least behind this claims autonomy, because autonomy is not absent, right? In Islamic law, it's just like framed in a different way. And I think this is, when we put autonomy as the sole, determiner of our relationships, I think then we miss a lot of things, as I think you've mentioned as such. Saadia, thank you so much for sharing this with us. We really look forward to your book, and maybe another conversation that will continue. Once the book is out, perhaps you should, just feel free that we'll contact you in the new year. But thank you so much for sharing this with us. We will make this available, for others and for those who had to go, and then we'll send you the link to that.
Thank you so much again for the invitation and for such a wonderful and rich conversation. I really appreciate it. And the opportunity to speak to the community in South Africa is something that I've been hoping for a long time. So it was really wonderful, to have that opportunity, and hopefully next time it could be in person, which hopefully.
Yes, I'm sure that that's going to be possible with, in the next few months or so. And
hopefully in some magical post-COVID world.
Yeah.
All right. Thank you so much again. I really appreciate it.